Welcome to the PREP Special Education Part B Section 2 video tutorial. During this video, we will discuss the relationship between special education and school discipline. This video tutorial is provided by PREP, the Parental Readiness and Empowerment Program, an initiative of the Lawyers Committee for Civil Rights under Law. For more information about PREP, please visit our website at prepparents.org. We offer helpful information, but this is not a substitute for legal advice. We do our best to be accurate, but rules can change and may vary by state and district. So let's get started. In Section 2, we will explore parents' rights and responsibilities when your child with special educational needs is disciplined in school. All children, including children without disabilities, sometimes have behaviors that interfere with their own learning or their classmates' learning. Children with disabilities can break the rules, like all children, or act in a way that may directly result from problems related to their disability. If this happens, different steps take place. This video will discuss what these steps are and how you can best navigate them. Due process rights are the first rights that you should learn about for special education issues related to school discipline. Due process describes the procedure through which parents may challenge a school district's disciplinary recommendations for their child. Every child has due process rights when suspended or expelled from school. Additional protections may apply to students with disabilities, which we'll address later in the video. Due process rights include, but are not limited to, oral or written notice of the allegations or charges against the student, an explanation of the evidence of the allegations against the student, opportunity for the student to present his or her side of the story, and a hearing scheduled right after the event. Children with special education needs have additional rights when disciplined because the IDEA governs the process for suspension or expulsion of special education students. The IDEA states explicitly that a free, appropriate public education must be available to all children with disabilities, including children with disabilities who have been suspended or expelled from school. So a student has the right to continue to receive an appropriate education even if he or she is suspended more than 10 total or 10 school days in a row. The definition of an appropriate education for a specific child is decided on a case-by-case basis, but an appropriate education must at least meet the state standards and conform with the student's IEP. In this video, we'll explore the specific rights that children with special needs and their parents have in two situations: short-term suspensions and long-term suspensions. In the case of short-term suspensions, which is a suspension of 10 days or less, a student with disabilities is subject to normal disciplinary procedures, whether or not the misconduct was a manifestation or because of the student's disability. During the short-term suspension, students with disabilities will continue to be provided with a free, appropriate public education, including access to the general curriculum and related special education services identified in the student's IEP. The IDEA ensures that students with disabilities receive the same procedural protections if cumulatively multiple short-term suspensions lead to more than 10 days of out-of-school suspensions over a single school year. In this situation, a manifestation determination review will be conducted, and the child and his parents have all the rights mentioned later in this video and the long-term suspension example. When a student with a disability in a special education program is recommended for a long-term suspension, or suspensions that make up more than 10 days, it results in what is called a change of placement. The school must notify the parents of that decision to impose a long-term suspension and provide the parents with a procedural safeguards notice. Additionally, the IEP team must determine whether or not the student's misconduct was a manifestation or resulted from the student's disability within 10 days of the decision to suspend. Your child's placement is the educational setting that the IEP team determined is the most appropriate for your child, and this placement is identified in your child's IEP. Typically, that educational setting cannot be changed without revising the IEP to reflect that the IEP team agrees to the proposed change in placement. A change in placement occurs when your child has been removed from school for more than 10 consecutive school days or 10 school days in a row. Or the child has been subjected to several short-term removals that total more than 10 school days in a single school year. Removal for less than 10 days in a row or in total is not considered a change of placement, so a manifestation determination review is not required. Once the school has changed your child's placement, the school must provide your child with services necessary to enable your child to appropriately progress in the general curriculum and advance towards goals set out in the IEP. The IDEA grants children with special needs and their parents another right through the Stay Put provision. This temporarily protects special education students from suspensions that are more than 10 days. The provision states that a special education student has the right to remain in his or her current educational placement while a school or law enforcement agency is reviewing the case or filing proceedings, unless the parent and school agree otherwise. Note that if special circumstances are involved, then the school can move the child to a 45-day temporary placement or an interim alternative educational setting, or IAES, without parental consent. These special circumstances include dangerous weapons, illegal drugs, or serious injury, and the school system can change a student's placement to an interim alternative educational setting for up to 45 school days if any of these circumstances are present, regardless of whether the behavior was found to be a manifestation of the student's disability. This means that a student may not stay put if the student carries a dangerous weapon to school or a school function, knowing he possesses, uses, sells, or attempts to sell illegal drugs at school or at a school function, or has caused serious bodily injury upon another student while at school or at a school function. Regardless of whether a student is allowed to stay put or is moved to an interim alternative educational setting, the next step in the review process is a manifestation determination review. The school can remove your child from his educational placement for up to 10 cumulative or consecutive days without having to hold a manifestation determination review. But the IEP team must hold a manifestation determination review before the school can permanently change your child's placement. During a manifestation determination review, the IEP team must first decide if the misconduct was manifested by or caused by the student's disability. The student must stay put in his or her school placement until the hearing is over, unless there are special circumstances that we discussed earlier, such as weapons, drugs, or serious bodily harm. There are two possible results of a manifestation determination review. If the IEP team determines that a student's misconduct is a manifestation of his or her disability, then the suspension must end and the student must be returned to his or her placement unless a new placement is agreed upon by the IEP team. A functional behavioral assessment must also be conducted if a recent one is not available. And a behavioral intervention plan must be developed or modified, and barriers, if present, to the implementation of the IEP must be fixed. However, if the IEP team determines that the student's misconduct is not a manifestation of his or her disability, then the suspension will remain in place, and the student can be disciplined exactly like any non-disabled student. Even if this happens, students are still entitled to receive the necessary special education services in another setting, and the IEP team will determine the best way to provide the necessary services in the alternative setting. Whatever the determination, the IEP team should meet to make sure the IEP was properly implemented. If it was not, any necessary changes should be made. But even if it was, parents should request a closer review to ensure the misbehavior does not occur again. Congratulations! You've finished Section 2 of the Special Education Part B video tutorial. The next video will be on harassment and bullying.